Hey, everybody. We are talking about criminal law cases, and I am Brian Foley. I'm the managing partner here at Houston Criminal Defense Attorneys, and we're going to be starting off with question number one here. What are the key differences between misdemeanor and felony cases, and how does this affect the defense strategy? So the biggest difference between a misdemeanor and a felony is the amount of jail time that you can do, and then the collateral consequences, meaning a felony means you can't possess a firearm anymore. It means you maybe can't vote anymore if it's a conviction. And then the potential jail time. In Texas, misdemeanors can go from where you pay a fine only on a Class C. Class B misdemeanor would be 0 to 180 days in jail and up to a $2,000 fine. A Class A misdemeanor would be from 0 to 1 year in jail up to a $1,000 fine. Then once you bump up to felonies, the lowest level felony is called a state jail felony. It's from 180 days to 2 years in a state jail facility. A third degree felony would be 2 to 10 years in prison, or the Texas Department of Criminal Justice, what they call it. Then you have a second degree felony, which is 2 to 20 years, a first degree, which is 5 to 99 years, and then last, a capital felony, which is a minimum of life in prison and up to the death penalty. So as you can see, the punishment range gets higher and higher. And the goal for a criminal defense attorney for felony cases is first to avoid that prison time, to avoid having your freedom taken away. For a misdemeanor case, oftentimes, especially if it's a first-time offense, we're not so worried about the jail time. The jail time is typically not an issue for a very first-time offender. It can be if it's violent in nature, someone was hurt or threatened. But for example, a DWI, jail time is a possibility, up to 180 days in jail on a first-time DWI, but it's very unlikely unless somebody's injured in a wreck. For a DWI, we're worried about the record. What is going to show on your record in the future? Is there a way to convince the prosecutor to dismiss the case, reduce the case, or reduce the punishment where maybe you just have to pay a fine? Maybe you don't have to do probation or jail. So the biggest difference from misdemeanor and felony is misdemeanor, we're normally talking about trying to protect someone's record. Felony, we're trying to keep you out of jail, out of prison. How can a prior criminal history influence the defense strategy for a new criminal case? So there are things, if you have a prior criminal conviction, meaning you went to jail, you were on probation, something like that for a prior case, you pled guilty to that prior case, that can affect the way the prosecutor charges your new case. So for example, on a DWI, if you have a third DWI, you have 2 prior convictions, it's no longer a misdemeanor case. It now becomes a felony offense, 2 to 10 years in prison for a third degree felony DWI third. Well, let's say it's not your third, now it's your 7th DWI. If you went to prison 2 prior times and you had 2 DWIs, let's say 2 misdemeanor DWIs, then you had 2 more felony DWIs. One of them you got probation. 2 of them you went to prison on separate trips to prison. Well, now those can be used to enhance your punishment range. You could be facing a minimum of 25 years in prison up to a life sentence. So that's what we call an official or a habitual enhancement, a punishment enhancement. You also have what's called the jurisdictional enhancements. In Texas, a jurisdictional enhancement means there's a crime that was committed that you were found guilty of or found to have pled guilty and got deferred probation, for example, on a DWI or an assault family member case. Even a deferred probation can be used to enhance the jurisdictional. And that means it takes a crime that was normally a misdemeanor and turns it into a felony. DWI is a great example. The other one that's a good example is assault family member. So if you cause bodily injury to another person by unwanted physical contact, it causes pain, causes a scratch, a mark, something like that, then that is definitionally assault bodily injury in Texas. If it's against a person in your family or someone you're dating or someone you were living in the same household with, like a college roommate, if you have a prior deferred probation or if you have a prior conviction or a jail sentence even, or maybe you just paid a fine, well then if you get a new case of assault family violence, meaning against one of those protected groups, family, dating relationships, or household relationships, well, that new one, the jurisdiction from misdemeanor court is going to be enhanced by your prior conviction or deferred probation. And that's what we call a jurisdictional enhancement. It changes it from a misdemeanor to a felony. And it'll go from, in that case, a Class A misdemeanor to a third degree felony with a max on the misdemeanor of 365 days in jail. And on the felony, 2 to 10 years in prison. So an extreme difference, very big very big changes you can see because of criminal history. A lot of people say, hey, isn't this unfair? I've already been punished for this prior crime. Well, the law in Texas says that at the punishment phase and during negotiations, a prosecutor or a jury can consider any prior bad acts of the defendant. And a prior criminal offense is something that's considered a bad act. The state would have to prove it beyond a reasonable doubt at the punishment phase of a trial, but there's nothing that stops the prosecutor from looking at even a dismissed case and saying, hey, well, I see this dismissed case on your record. It looks like you've been through the system before. I'm going to hold you to a higher standard now. I'm going to assume that you need more punishment to get the message. That's how prosecutors think about these things. What is the role of intent in a criminal case, and how do you prove it or challenge it in a case? So intent in this instance would mean what we would call a mens rea. Lawyers would call that mens rea. It just means the mental state. Every crime requires some kind of mental state, unless it's what we call a strict liability offense. Strict liability offense would be speeding. So for example, if you're driving and you're not paying attention, you're playing with the radio, you speed up to 85 miles an hour, speed limit's 70, you get pulled over. You go, I didn't even realize it. I just got this new Bugatti and it goes really fast. Couldn't even tell it was going that fast. Didn't even sound that loud. Well, besides the officer probably being jealous of your Bugatti, he's going to issue you that ticket, and he doesn't care that you didn't realize you were committing an offense. Your intent doesn't matter in a strict liability crime like speeding. It dispenses plainly with the mental state. But if the offense listed in the penal code does not clearly dispense with the mental state, then they're going to have it either written in the statute or the courts will imply one for you. So, for example, in an assault case, it will say that you intentionally or knowingly or recklessly engaged in conduct that constituted an assault. This would be like if you intentionally throw something at someone. You're looking at that person, you're trying to hit them, you throw a brick at them or something like that, and it hits them and it causes bodily injury. Maybe not serious bodily injury. Maybe a brick's a bad example because that could be an aggravated assault, which would be a felony. But let's just say no serious bodily injury, and you have a reasonable prosecutor who took the case as a misdemeanor. If you meant to hit him and you threw it at him, that's intentional. If you meant to hit the person next to him and you threw it in that direction, you probably knew that it could hit. You're aware of the risk, and that may be knowingly. And if you turn around and you don't really know and you throw it behind you and you're not really paying attention, but there's a crowd of people there, then you're being reckless about that. And you're consciously disregarding an unjustifiable risk in your behavior. And so that is the basis of intent. Intent is normally proved by a prosecutor through the actions of the defendant before, during, and after the crime. That's what we used to talk about when I was a prosecutor. Is we don't have a crystal ball, so we've never successfully read someone's mind to determine their mental state. So we look at their actions. That's how we prove somebody's mental state. We challenge that by testimony. We challenge it by the same evidence of their actions. Why would somebody have done this if they intended to do that? That's the kind of thing that we do in those kind of cases. How do you help clients navigate plea deals or negotiations with prosecutors? Well, a criminal defense attorney is always going to be the one that talks to the prosecutor. If you, the defendant, are the one talking to the prosecutor, you are losing ground on your case every word that you say, because the prosecutor is going to get a read on how they think you're responding to them. Do they think that you've accepted responsibility? Do they think that you're rejecting that responsibility or victim blaming? This is the way the prosecutor thinks about it. You may be totally justified. Maybe the victim was at fault. You acted in self-defense, right? The victim in the case being the person the prosecutor determined is the victim. Well, if you come with a certain attitude, they will clearly see, if they talk with you, they're going to see that attitude and they're going to make judgments about you and what you need depending on how they believe. The evidence shakes out. If the prosecutor thinks you're guilty because he read the police report, hasn't looked at the videos yet, they may make this determination. And if you talk with a prosecutor and you have a very clear understanding that what they wrote is not the truth, it's going to come off like you are challenging them or being aggressive with them. And a prosecutor, the last thing they want is to be challenged or have a defendant be aggressive to them. They're not going to stand for it. They're not going to talk to you anymore. They may cut off negotiations altogether. So you always want to have a defense attorney on your behalf arguing with the prosecutor for you. Prosecutors and defense attorneys negotiate cases frequently. You will start to get to know the prosecutors in your jurisdiction if you're a defense attorney, and you will use what you know to help mitigate the damages in some situations. So there may be 2 or 3 prosecutors assigned to a court. If you have one prosecutor hates certain type of crime, maybe you don't want to talk to that prosecutor about this one. Maybe you can talk to somebody else. You never want to get in a situation where they think you're prosecutor shopping, because your reputation and being able to deal fairly with anybody in the DA's office is an important thing. And your defense attorney will know how to do that. So that's as far as like the actual negotiation part. How do you help clients navigate a plea deal? Well, I think you have to be honest with a client, and you have to be honest from the very beginning, because at the end of every criminal case is normally a very difficult decision that has to be made, either to take or reject a plea bargain or to go to a trial. None of those are easy decisions. And so you have to know as a defendant or a client that your attorney is telling you the truth. Because if you can't trust that advice to make that very important decision to end the case in some way, then you've basically wasted every penny you spent on that attorney. So you have to have an attorney that's willing to be honest with you and tell you where they think things really stand. What are alternative sentencing options, and how might they apply in certain criminal cases? So an alternative sentencing option might be something called a pretrial diversion or a pretrial intervention. It's the kind of thing that you would enter into with a client who has no criminal history, who is respectful with the police, maybe has been involved in the community, done volunteer work before. You can present that information to somebody, namely a prosecutor, and that prosecutor can agree to either dismiss charges or reduce charges based on this, you might call alternative sentencing. A traditional sentencing would be you agree to a plea bargain, you plead guilty. An alternative sentence, you wouldn't plead at all. You would just enter into an agreement with the prosecutor, maybe do community service, be supervised for a little while, or complete an online course and then have the case dismissed after that. What should somebody do if they're facing criminal charges but they are innocent? Well, it's really the same process whether you're guilty or innocent. People have a very difficult time with this because the system doesn't know which one you are, and the system really doesn't care. Our criminal justice system is designed to have a process that goes forward, not really based on truth. When you are looking at your criminal case, you want an attorney that understands first that if you're innocent, you have to fight to get a dismissal. But if the risk of going to trial based on the evidence is that you could be convicted even if you are innocent, you have to have an attorney that also is willing to tell you that. And if there's an off-ramp, if there is an alternative sentence that can lead to a dismissal, that could lead to an expunction the same way that a not guilty verdict at trial is, you need to explore that option, because the last thing you want to do as somebody who is innocent of an offense is end up in a trial where 12 people or 6 people from the community are deciding your fate instead of being able to negotiate it and have control of that process. You should never plead to something you're not guilty of, but you should also have a clear understanding of what the risks are, because you would not be the first person who is innocent and still convicted in the criminal justice system in America. What should a person do if they're under investigation but they have not been formally charged? The easiest answer, the fastest response I can give is do not talk to the police. If you're under investigation, you have not been charged, do not talk to the police, certainly not on your own. I tell people this all the time. If an officer calls you and wants to talk to you about something you don't know what it's about, it's clear to you that, either it's not about something you were just a witness of, you think it's something about you, or in any case, really, anytime a police officer calls you, the only thing I would ever tell a police officer is, thank you for calling me. Let me get your name, officer, and let me get your phone number. I'll have my attorney give you a call back. Then you call a criminal defense attorney and try to figure out what's going on. And your defense attorney can talk to the police for you. We do what's called a pre-charge representation, where even though no charges are filed, we'll represent somebody, determine whether we want to give a statement or not. A lot of times this happens in federal cases where maybe a charge hasn't been filed, but a target letter has been given to somebody, and that indicates that a federal prosecutor is considering charges. But it may be that person is not the person they really want to get. It might be that you have knowledge of somebody else that the prosecution's more interested in. And that would be one of the only instances where I would suggest talking to the police or talking to a prosecutor can serve to your benefit. There are very few instances where that's true. Most of the time, the best advice is do not make a statement to the police. Another thing you can do if you think you're being charged with a crime but you're not sure is call a bail bondsman. They can look up in the warrant system in their area and pretty much everywhere to see if you have a warrant, and they'll know they can help bond you out, and you can talk to an attorney as well about the bond procedures. What rights do individuals have when arrested for a criminal offense, and how can those rights impact the case? You have a number of constitutional rights when you get arrested. The first is the right to remain silent under the Fifth Amendment. You also have a Fifth Amendment right to an attorney and a Sixth Amendment right to an attorney. The Fifth Amendment right to an attorney relates mostly to custodial statements, meaning if you're under arrest, you've been put in handcuffs, the formality of traditional arrest has been applied to you, you don't think you're free to leave, those kind of things, then you have the right to an attorney before there's any kind of questioning. And you really shouldn't be saying anything anyway other than, thank you, officer, let me get your name and number, have my attorney call you back. But if you're being arrested, there's no need to say even that. You just say, thank you, I need to talk with my attorney. And they have to do what's called scrupulously honor your request for an attorney. They can't ask you any more questions. They can still take you to jail. They can still book you. They can ask you how much you weigh, what your eye color is, and your address and things like that. Standard booking questions don't fall under your Miranda rights under the Fifth Amendment, but any other statement or question about the criminal offense that you're there for is going to be considered privileged and part of your constitutional Fifth Amendment right. You also have the Sixth Amendment right to an attorney at any critical stage of a proceeding. You have an Eighth Amendment right to reasonable bail and reasonable bond be set so that you're not unnecessarily detained prior to a finding of guilt. You also have the Eighth Amendment right against cruel and unusual punishment, which says that it's been applied mostly in death penalty cases, but one thing that was happening at the founding of our nation that no longer happens as punishment are different tortures, like, in the town square and the gallows, or thumb screws are a thing that they used to do to people. And so a lot of the things that the Eighth Amendment cruel and unusual punishment provision protected against, we just don't see anymore because people actually respect the Eighth Amendment. How does the concept of self-defense work in a criminal case, and how do you prove it in court? So self-defense in like an assault case would be under Chapter 9, and it's an affirmative defense, meaning that it's the burden of the defendant to produce some evidence, either through cross-examination or positive evidence like testimony from a defense witness, that shows that self-defense may apply, that conditions occurred that day where the use of force was justified by another person's imminent use of unlawful force against the defendant. Self-defense has to be immediate. It has to be imminently necessary. And you prove this in court, again, through testimony, maybe photos, videos. If there are indications of self-defense, sometimes that occurs through markings on the defendant's or the victim's knuckles, right? So if you punch somebody, then you may have some bruising or redness or marks, cut even on your knuckles. And if the victim says, well, I never threw a punch, he just attacked me, and the defendant says, well, he punched me first and then I defended myself. Well, if the victim says they never threw a punch and they have indications of doing so on their knuckles, that's going to be good evidence of a way to prove things in court, that the statement of the victim is not true, that the statement and the self-defense of the defendant is justified. And then number 10, our last question here, how does the legal system treat juvenile offenders, and what are the main differences in defending a juvenile versus an adult? So juvenile cases are criminal cases, but they're quasi-criminal, quasi-civil, meaning part criminal, part civil. They actually have jurisdiction under the family code to impose sanctions based on penal code and other criminal violations in the state of Texas. So if you can be arrested for it as an adult, you can be arrested for it as a juvenile once you turn 10. So from 10 to 17. 17 and up is an adult in Texas for both the consent law for sexual activity as well as criminal offenses. Juveniles are given very different considerations. One of the things that is the focus of juvenile law is the rehabilitation of the child. It's not so much focused on what we call retribution theories of criminal law. Retribution theories would include like prison sentences, things like that. You deserve this because you did this bad thing. Rehabilitation is really the key in juvenile cases, although juveniles have far fewer rights than their adult counterparts. So, for example, an adult has a right to a bond, where even in misdemeanor cases, whereas a juvenile can be detained at the discretion of the court. An adult has the right to not be arrested without a warrant, whereas a juvenile can be, again, detained by the court at the order of the court alone, even though it's not pursuant to a warrant. They can basically make an arrest, a warrantless arrest, even at school. They can just pick them up at school, make that arrest. There's a lot of different rules for juvenile cases on how they must be admonished. They can't have a statement gotten from the juvenile without a parent and the admonishment of the court, things like that. It often happens where they're talking to the juvenile at the school. They're not really under arrest, and some of these things aren't applying yet. And so it's a big difference between juveniles and adults. Again, adults more focused on the retribution theory and punishment. Juveniles more for rehabilitative options. Almost any juvenile charge is going to be automatically sealed when you turn 19. You can get it sealed earlier than that when you turn 17, but you cannot get an expunction on a juvenile case. Only adult cases can be expunged. The difference there being one is sealed from public view but can still be seen by government entities, and that's the non-disclosure or the sealing of a juvenile record. And an expunction actually requires the government to delete any records if the case ever existed. That's only available for defendants who are 17 and up. That is all the questions we've got today, folks, and I appreciate you guys tuning in. We will see you next time, and if you like what you saw, don't forget to like and subscribe. Thank you.